why this committee has been formed now, what exactly is the composition and mandate of this committee.
One is to review constitutional provisions, laws, and administrative framework governing union-state relationships. Second one, that is very important, to give suggestions regarding those subject matters which are already transferred from state list to concurrent list.
What has been the demands of few of the states who have been asking for more autonomy in the past?
And when we talk about state autonomy vis-a-vis at the same time holding the paramountcy of the unity of India, then definitely things were innate there in our federal arrangement.
What are the issues currently regarding center state in India?
You have countries like United States, Australia, Switzerland, Canada, or for that matter, Spain, Belgium, Malaysia. The federal arrangements are different. Okay.
Hello everyone, welcome to the Perspective series. In this episode, we are going to discuss the recent development towards the Indian federalism. Recently, a high-level committee has been formed by the government of Tamil Nadu to review the center-state relations and suggest measures to strengthen state autonomy. So, why exactly this committee has been formed? What are the historical and legal context on the basis of which states have been demanding more autonomy? What implication it will have over the Indian federal system? All such issues we are going to discuss in today's video with our expert panel members today. A very warm welcome to all of you. So Ashok sir, I would like to ask you why this committee has been formed now. What exactly is the composition and mandate of this committee?
Paritoshi, on 15th of April 2025, Government of Tamil Nadu had constituted a committee, that is a 3-member committee, high-level committee, and Chief Minister of State under Rule 110 of State Assembly came out with announcement that committee will be headed by former Judge Supreme Court, Justice Kurian Joseph. Other 2 members will be K. Ashoka Vardhan Sethi, who is a retired IS officer and former Vice Chancellor of Indian Maritime University. Second member will be M. Naganathan, who was a vice chairperson actually, of State of Tamil Nadu Planning Board. This committee is given 2-3 responsibilities. One is to review constitutional provisions, laws, and administrative framework governing union-state relationship. Second one, that is very important, to give suggestions regarding those subject matters which are already transferred from state list to concurrent list. And third one, to give suggestions and strong proposals to enhance and to strengthen state autonomy as well as Indian federal setup in our country. Apart from these all three, this committee is mandated to examine all past efforts relating to Rajamanar Committee report, Sarkaria Commission report, and Punchi Commission report. Paritoshi, if we will see the context and the time when this committee is constituted, we will have to see the judgment of Supreme Court in Government of Tamil Nadu versus Governor of State in 2025. This case actually is related to the very nature of federal structure of this country. From my point of view, Indian Federation is very unique in nature, and it is a perfect example of a reconciliation of state autonomy with paramount objective of maintaining unity and integrity of the country. So we are supposed to ensure state autonomy without disturbing unity and integrity of the country. And that the same thing, Supreme Court reaffirmed the primacy of parliamentary democracy in India, and at the same time cooperative federalism in our country to strengthen and to ensure unity and integrity of the country.
So now that we know the recent issue at why this committee has been formed, so certainly this demand for more autonomy is not new. Many other states have been asking for more autonomy. So Shruti ma'am, would you tell us what has been the demands of few of the states who have been asking for more autonomy in the past?
Okay, sir. So I would like to take forward the discussion from sir only. When sir said that the uniqueness of our Indian federation, that is the holding together federation, and when we talk about state autonomy vis-a-vis at the same time holding the paramountcy of the unity of India, then definitely things were innate there in our federal arrangement. But somehow, till 1967, because of the same political formulation at the center and in most of the state, the things were fine, as in the center-state relationship had not come up to that level what it's right now. But in 1967, which I feel is an epistemological year as far as the political history of India is concerned, because two events happened at the same time. One, there was rise of regional parties somewhere down south, and two, there was decline of what Rajni Kothari says as the one-party dominance of the Congress party system. So now with these two factors coming up, there was rise of the mushrooming of regional parties all across the state. And of course, as I said, whenever the party formulation differs from the center and the state, many often demands comes up. So 1967, 2 years down the lane, it was same Tamil Nadu coming up with a state-initiated initiative or a commission which is called Raj Mannar Committee. Now, Raj Mannar Committee was basically looking into all aspects of centralization of state power, as in center power, that was revamping the entire idea of Article 3656 or looking into other aspects also. So 4 years down the line, again, West Bengal came up with the West Front Memorandum. And as far as this particular memorandum is concerned, again, it was a state-sponsored committee. It was looking into, again, the center-sponsored all kind of initiative of centralizing tendencies, especially regarding the governor rule, Article 356, Article 200, Article 131. So these were the ways in which slowly and steadily, in different parts of the world, this idea of India, the idea of state autonomy was very much rising up. So here I would like to even put that keeping into mind the unique nature of our federal aspect in India, I would say it was a kind of journey which we started having from a unique federation to a conflictual federation. And I'm sure the journey will continue taking it forward to cooperative federalism. And likewise, therefore, in order to achieve to this aim of a coexistence between center and state in the same ecosystem, we came across with some other committees like the Sarkaria Commission or the Punchi Commission. So I'm quite hopeful that the issue will move forward in a more positive trend.
Now that we have discussed the idea of why more state autonomy is required, the underlying theme is center-state relations. So recently, many issues have been come up regarding center-state relations now. So Amil sir would like to take us or discuss what are the issues currently regarding center-state in India.
So that is a very pertinent question. First of all, the kind of federalism that we adopted, there is no agreed definition of federalism. Okay, you have countries like United States, Australia, Switzerland, Canada, or for that matter, Spain, Belgium, Malaysia. The federal arrangements are different. Okay, India, the federations can be of two kinds. It can be arising out of integration. For example, the Quest, the 13 colonies in the United States coming together, or too big to administer, so it is dividing, like Canada. The whole idea of federalism is distinct from separation of powers. Why? Because separation of powers has been given by an individual, Montesquieu, in his book, The Spirit of Laws. But federalism has come from the experiments in the American Constitution. So if you go deeper into the subject, there is no agreed definition of federalism. Federalism as an arrangement differs from place to place. There are some countries which came together due to some necessity, some 13 provinces came together, now you have 15 United States. Or Canada, too big to administer, so it was divided into states. Or you have Spain, Belgium, Malaysia, Australia, there are various experiments. So the Supreme Court on 11th March 1994 in S.R. Bomai case said, let it be said that federalism in India is not a matter of administrative convenience. It is an outcome of our own process and ground realities. So federalism also reflects the diversity of India. And the Supreme Court has consistently said that states are not mere appendages of the center. Even Dr. Ambedkar on 25th November 1949 said that the states have an independent constitutional existence, what he wanted to convey, and they exercise their autonomy. Okay, leaving this federalism thing. So since there is no agreed definition of federalism, a country more closer to Australia or for that matter US is said to be more federal. There is no, but yes. Undoubtedly, federalism is the part of basic structure. So what is basic? What are the issues that are emanating? First issue is, unlike the United States, where more powers are with the Senate, like ratifying an international treaty and all, but every state, North Dakota, South Dakota, or California for that matter, they are equally represented. But in India, we have Lok Sabha as well as Raj Sabha. In Raj Sabha, you don't have an equal representation, neither in Lok Sabha. So the lines I'll be talking about the issues. Article 82 of our constitution, delimitation. Okay, for that, if there is a delimitation exercise that is conducted after 2026, of course, the states in the southern part of the country, that remains a key issue. First thing. Second thing is Finance Commission. You see terms of reference of 15 Finance Commission, the previous one. In terms of reference of 15 Finance Commission, it was written that states which are implementing the flagship schemes of central government, or states which are expanding the GST net, that was quite a wonderful one, but implementing the flagship schemes of central government. Getting my point? So this is something which is the founding mothers and fathers in the Constituent Assembly have provided for Finance Commission. Some states are of the opinion that this should not be linked to their performance in how they are implementing the flagship schemes of central government. So one, the issue arising out of delimitation. Second, the issue arising out of Finance Commission and the terms of reference of 15 Finance Commission, although in order to compensate the states, especially in the geographical south, I don't use the term South India. Every inch of this country is as important and beautiful. I'll say geographical south. In the geographical south, those states which have relatively better total fertility rate, because we took 2011 census, so they to compensate them, they provided for demographic performance as a criteria. So Finance Commission, because Tamil Nadu is of the opinion that they contribute more to what they get. So first, delimitation. Second, Finance Commission. Delimitation, of course, remains a thing. How it comes out, we need to wait. Third is the frequent misuse of Article 356. Between 1960s and 1997, it was invoked more than 60 times. First few years, between first 18 years, it was invoked 13 times. So that also, nowadays we hear less about the same, more about 10th schedule and election symbols order. But that the misuse of Article 356, the three-language formula, that also, you know, what you call Tamil Nadu has expressed its reservations over the same. And one more thing with respect to the provisions of, for that matter, you have the GST with the incorporation of indirect taxes. Most of the states' autonomy except liquor for human consumption, aviation turbine fuel. You have motor spirit, commonly known as petrol, natural gas and diesel. Other than these five, most of the things have been integrated. So their autonomy to tax independently has been taken away. So financial aspects, then the role of governor, that also remains a key challenge, that how the governor acts as an what you call link between center and state. Of course, governor is an agent of the center. One last thing. This whole issue started from Section 14 of the National Medical Commission Act 2019. Entry 25 of the concurrent list says education, including medical education. So exercising powers under Entry 25 of the concurrent list, the Parliament of India enacted National Medical Commission Act 2019. Section 14 of the National Medical Commission Act 2019 says there will be a uniform medical test for all the undergraduate admissions and postgraduate in the country. With postgraduate, there are certain conditions. Undergraduate, uniform, entrance test. So Tamil Nadu is of the opinion that no, we will, in our state, medical colleges, we will take admission on the basis of class 12th marks, not on the basis of NEET marks, because with the advent of NEET, students from opulent background, they get access to quality education because of their relative, strength in paying for the education. So Section 14 of the National Medical Commission Act 2019 makes it mandatory for a uniform entrance test for undergraduate medical courses across the country. So this is a law made on concurrent list, which of course, if there is an inconsistency between the parliamentary law and state law on concurrent list, the parliamentary law shall prevail, unless the law passed by the state legislative assembly receives the assent of the president, Article 254. So this law was also passed, the legislative assembly passed the law to overcome the law of the center, which was also rejected by the Honorable President of the Republic. So I would say delimitation, the terms of reference of Finance Commission, misuse of Article 356, the provisions related to what you call the National Medical Commission. These are the key issues that have remained a point of contention between center and the states. It can go on, but for the time being, this is.
Certainly, again, we had a very comprehensive understanding of the whole issue, that what exactly is the demand for state autonomy, what exactly are the issues around center-state relations. Let's take the discussion a little bit forward. Let's discuss the fundamentals regarding this whole issue. So, Ashok sir, what are the constitutional provisions which states invoke whenever they ask for more autonomy, and how has Supreme Court responded to such demands?
Paritoshi, Constitution is a living document, and some provisions I can mention here, if you'll allow me a little bit more time. Article 1, Article 131, Article 245, 246, and current controversial Article 200. Article 1 itself, I think, is the most important one to understand the very nature of federal system in our country. India is a union of states. We are union does not mean we are central. We are union, it means we have separate state governments without any kind of compromise the unity and integrity of the country. We are union with a system that will cement a relationship between union government and the state government. We are union to understand the responsibility of the union government as well as the state government within the limit of the constitutionalism, constitutional morality, and the very spirit of constitution should be taken care of. States, when will perform, union will perform. When union will perform, states will perform. Because from my point of view, the very first article of this constitution is based on system approach, and all states are subsystem of a system called India. So all subsystems are expected to perform in their own way, but at the same time there must be a coordination between and among all states along with the union, means vertical and horizontal responsibilities should be taken care of and coordination should be maintained, the first one. As far as the second provision I was supposed to take, article number 131, that is related to original jurisdiction of Supreme Court. So that original jurisdiction of Supreme Court was inserted in Constitution by Constituent Assembly only to ensure federal philosophy of the country. If any state will face any kind of grievances or any kind of complaint against union government, will come to Supreme Court, and Supreme Court will try to maintain equilibrium between union and state. The third one, that is related to legislative federalism in our country. Article 245, that deals with the doctrine of territorial nexus, and Article 246 and the 7th schedule, that deals with doctrine of pith and substance. These two articles actually ensure legislative federalism in our country. Unfortunately, in today's world, when in a recent scenario we are facing a very big problem, that is related to legislative federalism. Earlier we were facing administrative problems or the fiscal problem. We were talking about administrative federalism, we are in trouble, or fiscal federalism is in trouble, but nowadays legislative federalism is in trouble. And that legislative federalism is in trouble not because of Article 245 or 246, but because of 200. Sir already said that 356 was a disturbing element, although Dr. Ambedkar said hardly it will be used, but we proved Dr. Ambedkar wrong. So nowadays we are using, when I am talking we are using means governors, they are using Article 200, and the way they are using Article 200 in the eye of Supreme Court, not on the line of federal philosophy of the country. So these provisions are given to establish India as a federal system. And what I think, after analyzing whatsoever given in our constitution, our federalism is nothing but a political interpretation of geographical realities of the country. Because we are a very big country and it will be essential for us to divide our country into a number of administrative units to run our country effectively, efficiently, and in a coordinated manner. So these provisions are very clear provisions, and the way we are interpreting is the main issue. As far as the judiciary's response is concerned, I will try to point out the judgment given by Supreme Court and observation of Supreme Court in 2023 when State of Punjab was a Principal Secretary, Governor Punjab. Supreme Court came out with a very hard word and in fact, Supreme Court said Governor is not expected to play with fire. So now, in recent judgment, again Supreme Court came out with a very hard word like if Governor will sit on bills which are duly passed by state legislature, it will be arbitrary, it will be illegal, and it will be non-existence in nature, it will be erroneous. So that cannot be accepted. And that's why Supreme Court used Article 142, that is a very rare thing. So I think first time in the history of after Indian independence, Supreme Court used 142 to give assent to all bills which were pending before the governor or the president of India. So I think that in judgment of Supreme Court will change the very interpretation of Article 200, and it will not affect only Article 200, it will be instrumental behind the interpretation of the very legislative power of President of India as well as the governors of the state. What I think so. So better for us to think in a positive way to make our federal system strong. And the moment we will try to make our federal system strong, we will definitely give autonomy to states and we will respect the functions of the state, and the states must be allowed to perform in their own way without disturbing the constitutional spirit of the country, and they also should be within the limit of the constitutional morality and federalism.
Now that sir has explained very beautifully the whole idea of what does the constitution says about all of this. So ma'am, I would like to ask you, let's move beyond Tamil Nadu. Let's discuss what exactly will be the implication of giving autonomy to the states over the Indian federal system.
So as far as the entire recent controversy is concerned, I would say that this is one classic example to showcase that what are the challenges as far as Indian federalism right now and might be in the future would be facing. So it's a amalgamation of so many concepts within federalism. There would be conflictual federalism. There could be, this is an example, or this could create ideas regarding asymmetrical federalism. There could be bargaining federalism, begging bowl federalism, and ultimately our ultimate agenda of reaching to that good idea of cooperative federalism. So as far as implications are concerned, point number one, I would say the present Tamil Nadu stance of creating and taking a state initiative, of forming a state committee to revamp center-state relation, I believe this is one step which could open the floodgates for institutionalization of such state demands in future. So in future, of course, state can come up and can structure their demand in this way. And I believe this could be a journey of state being too reactive to state being more proactive as far as the federal dialogue also is concerned. So this is going to be the first implication. The second implication I would say is that perhaps it would give a big push or a momentum to the already existing constitutional mechanism for conflict resolution between center and state. So the hitherto underutilized agencies like interstate councils or the zonal councils, of course in future they would be gearing themselves up. The third important implication I believe is that a Pandora box of a few more state-related demands can definitely come up in future. One very fine demand which is coming up since GST implication has been regarding GST compensation. Another could be, as sir was saying, terms of references regarding finance commission, and in this regard even Tamil Nadu has said that if 1 rupee we are contributing, how much we are getting back is really minimal. So it could open Pandora box of such new demands in future as well. Fourth implication I believe is that definitely this would involve a judicial intervention. So in future there could be good judicial activism or judgment regarding it, which of course could be one of the, and that's I believe sir is the core aim of a judicial system. Where federalism may, out of the important features of a federation, one of the feature is to have an independent and impartial judiciary. So I believe the functionaries and the functions of judiciary is definitely going to come up to another level. Apart from that, I would say, if state are coming up with these kind of demand, and in order to settle down things, we never know, an idea of asymmetrical federalism can also come up, where custom-made or tailor-made governance structures for the state could be created. And so last but not the least, I would take it forward. So in forward, I would say that the implication of federalism should not only be viewed internally. I believe the implication of a conflictual federalism, center-state tussle, do have a replication or an implication in the foreign policy. So definitely in future also, if the things are not being settled down, especially concerning states like West Bengal, this issue definitely can have a great implication. So if we remember in 2011, so we were so near to finalization of Tista Water Agreement, and at that time it was West Bengal which backed out because of the conflictual issues, and this is the reason till date we are not able to come out with a Tista Water finalization. And so now to the situation in Bangladesh, we all know it has all gone China way, so there is a big question mark on the future of this kind of good memorandum of understanding or confidence building measure. Also, sir, I would like to take this as an opportunity that it's not only the story of asymmetrical federalism or begging bowl federalism. I would say we should try to figure this issue from n number of perspectives. It could have a political angle also, keeping into mind the next year elections happening in Tamil Nadu. So you need to figure federalism and the conflict from all perspectives. So it has to have certain political angle to it. It also have to have certain party formulation and difference between center and the state. That also plays a role. That is also one of the reasons why West Bengal, Punjab or Tamil Nadu are core as far as state demands are concerned. And third, also I would say we need to figure out issues. Like sir also said, there is a huge number of issues in which I believe irrespective of political formulation you are having, state might have different opinion. So here I would like to say that if West Bengal is right now appearing and has been appearing as an inhibiting actor as far as Tista Water finalization is concerned, the same West Bengal appeared as an enabling actor when we come across with Ganga Water Treaty in 1996. It was same West Bengal which helped India come out with the Farakha Barrage controversy, mending the relation between India and Bangladesh to an extent that we started calling it as Shonali Adhyay. So my point is, it needs to be referred from different angle, not exactly from a core traditional center state issues, or we can't guillotize few states saying that these are only the states which are taking forward the demand for autonomy. So in the nutshell, I would say we had a beautiful journey of us emerging as a unique federation. Cut to, we came up to a conflictual federalism ecosystem, but the essence has to be, or the ultimate idea has to be cooperative federalism, which I believe constitutional morality definitely is going to uphold. Judiciary is of course there, and we of course civil society members needs to have this kind of interaction and brainstorming so that new ideas can definitely come up.
Okay, now we have got a very diversified perspective regarding the whole issue. So, as ma'am told, the ultimate goal is to get to the idea of cooperative federalism. So, Amil sir, how do you see what is the way forward with respect to centers and the state with the idea of cooperative federalism in the near future or regarding India?
Ma'am has already covered very comprehensively, ma'am. I would say that this was envisaged in the Constituent Assembly also. Because wherever you have federalism, you have state of Texas versus federal government. So in India, we had in the past state of Rajasthan versus Union of India state. So the conflicts are bound to happen, but should not be politicization of federalism. Okay, the commitment towards the constitution should be great. One just very small example. On 4th July 2018, Supreme Court delivered a verdict on Delhi, Government of NCT of Delhi versus Union of India. In Article 239AA Clause 4, it is written, the Lieutenant Governor shall, if there is a difference of opinion between LG and Council of Ministers on any matter, the word any with single inverted comma, on any matter. Supreme Court said it can be, if there is a difference of opinion, it can be sent to the President. Supreme Court said any does not mean every. You may have the option to send it to President, but it should not be every. First thing. Second thing, the fiscal federalism is what you carefully crafted in such way that is tilted towards the center. Not because the founding mothers wanted to give this to the center, because they knew that some states are rich, some states are relatively poor. So if center will be distributing the revenue, it will balance it out. So the state of Tamil Nadu also this very point that it has to be taken into consideration. Third important thing is that India, I always say India is not a land of melting pot where all the cultures lose their identity and there is only one final soup that is made. India is a land of salad ball where they stay together without losing their identity. We are a classic case of asymmetric federalism. Article 371A for Nagaland, 371F for Sikkim, 371G for Mizoram, 371 for Maharashtra and Gujarat, 371J for Karnataka. So we have 6 scheduled in 4 states. There are 10 autonomous district councils. We have scheduled areas. So many. You have Panchayat Extension to Scheduled Areas Act 1996. There are so many. So I think what can be done? One, the combative federalism should be kept into the back burner. There must be commitment towards the constitution. How? One, the judgments of the Supreme Court. So there is an independent body to adjudicate upon the dispute between center and state. So Article 131, the judgment should be implemented in true spirit. Second, the state should not politicize actions against the center for political things, and center also not should refrain from interfering with those states which are particularly ruled by the parties that are in opposition. Okay. Next, last year zonal councils, interstate council was reconstituted last year only. It has been reconstituted. That's an excellent avenue. Zonal councils under State Reorganization Act, Nehruji rightly said, to develop the habit of cooperative working. So for issues between states related to border disputes like Maharashtra and Karnataka, zonal council. To discuss issues of pan-India, you have interstate council. You have Team India wing under what you call Niti Aayog, which can bring all the states together. You have Article 282 of the Constitution, discretionary grants. Thankfully, we don't hear any such discrimination in that. So interstate council, zonal council, implementing the judgments of Supreme Court, frequent meetings of the interstate council and Punchi Commission, Sarkariya. We have ample of literature. What is missing is commitment. We have ample of literature, and the Constitution of India has been so drafted that it itself provides avenues to solve these things. So if I think that if there is a commitment to the Constitution and politicization of federal issues is not there, then without a shadow of doubt, I don't find a reason why we cannot come out. And we have strengthened over the period of time. We have strengthened, and I'm very sure and hopeful that over the period we will come out better as Team India.
Thank you so much, all of you. We have got a very insightful idea regarding the whole issue. So to our viewers, thank you so much for joining us today. What we got to know is that the center-state relations in India are not static, it is ever evolving. And with this particular issue, please comment that what are your viewpoints with regarding how do you see we are going to move forward with the idea of cooperative federalism in India. Until next time, stay updated, stay aware. Thank you so much.